Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, if you're enjoying our legal education content, please remember to subscribe and hit that notification bell so you can get alerts of our live streams like the one that you're watching right now. For today's live stream, we are doing an opinion released this morning from the United States Supreme Court in the case of Terry versus the United States. So let me tell you a tale. Once upon a time, Congress had a law that penalized crack cocaine much more severely than powdered cocaine. Now, whether or not this is good or not, it's a thing that happened. And crack cocaines were principally sold in inner city neighborhoods and principally impacted African Americans. And this is considered bad. So Congress decided, okay, this is bad. We can fix this. Or, we may fix this. To use exactly the right word. We may fix this. Because ex post facto only applies if we're making things more criminal, not less. So Congress can always go backwards. They can always say this thing that was illegal, it's now legal, retroactively. It was always legal, right? Or they can say, hey, this crime that had this sentence, it now has this lesser sentence, retroactively, right? Congress can always make things, may always make things, I keep getting the verbiage wrong, may always make things better. I keep having to correct myself because whether or not they can make things better is exactly the issue that brings us here today. Because, they failed. They tried and they failed. They may do it, but can they do it? No. As it turns out, no, they can't. No, they can't. No, they just can't do that. So no. So we have to discuss this complete Congress fail and make them realize that they don't know how to law, but it's okay. It's not like they have lots of lawyers or a Congressional Research Service or support staff or lobbyists or anyone else who could review these things, but it's okay. It's probably not important for anything. So let's get started with this. In the case of Terry versus the United States, super exciting. Very exciting. Justice Thomas writing the opinion for a unanimous Supreme Court. In 1986, the Congress established a minimum penalty for crack cocaine. If the quantity of cocaine involved in an offense exceeding a minimum threshold, then the courts were required to impose a heightened sentence. Different levels of bad have different sentencing of bad. Congress set the quantities far lower for crack offenses than powder. So the amount needed was less. But it since has narrowed that gap by the thresholds for crack offenses more than fivefold. Okay, so Congress went back and said, okay, these disparities are too much. We're going to reduce them. Great. Then Congress wrote this thing called the First Step Act of 2018, which attempts to make those changes retroactive and attempts to give certain crack offenders an opportunity to receive a reduced sentence. The question here is whether crack offenders who did not trigger a mandatory minimum qualify. They do not. So this is just a total fail. In the mid-1980s, the Congress of the United States witnessed a steep surge in the use of crack cocaine, and news of high-profile cocaine-related deaths permeated the media. Witnesses before Congress and members of Congress themselves believed that a crack epidemic was also fueling crime. Crack, they said, was far more addictive and dangerous than powdered cocaine. It was cheaper and easier to obtain, and these and other factors spurred violent crime. In response to these concerns, Congress quickly passed a bill with near unanimity. Congress said this is bad. We want to have a law against this because it is bad. The new law creates a mandatory minimum penalty for various drug offenses and set much lower thresholds for crack. The act included 2 base penalties that depend on drug quantities. Okay, so we have different levels for different amounts. There's a 5-year minimum triggered by either 5 grams of crack or 500 grams of powder, and a 10-year mandatory triggered by 50 grams of crack or 5 kilograms of powder. So it's a 1 to 100 ratio in the law in terms of the quantities. The act also created a third penalty: possession with intent to distribute an unspecified amount of a Schedule 1 or Schedule 2 drug, which technically crack is a Schedule 2 drug because cocaine is a Schedule 2 drug. Cocaine is less regulated than marijuana. Did you know that? You may not have known that. I'm here to help you. I'm here to help you tell you these things. Yes. In the U.S. federal system, there are 5 different schedules. Schedules 1 through 5. Some states have different schedules for their scheduling, right? And so different drugs are in different schedules, all right? And so Schedule 2 drugs you can get with a prescription. They're more regulated. They're more restricted. It requires, more oversight from the FDA and DEA and stuff like that, right? But you can go to a pharmacy today and get a Schedule 2 drug. Not necessarily all Schedule 2 drugs, because it depends on the nature of the drug, but you can. But not Schedule 1 drugs, because Schedule 1 drugs have no possible medical use, by definition. So marijuana is a Schedule 1 drug because it, by definition, has no possible medical use because it's a Schedule 1 drug, which means it has no possible medical use because it's a Schedule 1 drug. If it sounds tautological, don't think about it too hard and you'll be a lot happier. But cocaine is Schedule 2 because it has a medical use. It's used as a nasal anesthetic. It's used. I don't know how frequently. I assume there's other options, but it's used as a nasal anesthetic in hospitals. So yes, your doctor can actually prescribe cocaine, but not marijuana. Anyways, before I move on too much about that, petitioner was convicted under this relevant act and subjected to the third penalty. All right, so okay, so we got 3 different possible penalties in play, right? We got 3 different penalties in play. You have at least 5 grams, you have at least 50 grams, or other, which is presumably less than 5 grams, right? You have at least 5 grams, you have at least 50 grams, other. Great. So our friend here was in the other category, which means that he didn't have at least 5 grams. I believe he had 4 grams to be precise. Yes, in fact, it says that. At sentencing, they determined the offense involved about 4 grams of crack, which is distinctly less than 5. Right about now, he probably wishes that he had been convicted of 5 because he was only convicted of 4, and it's going to come burn him because Congress can't write a law. It also determined petitioner was a career offender under sentencing guidelines. The career offender guidelines controlled because they recommended a higher sentence than drug quantity guidelines. The district court sentenced the offender to 188 months, the bottom of the range. So that's a lot of time for 4 grams with some other stuff because he's a career offender. So he has some criminal history. So that's going to augment it. But we're giving him 188 months in prison. That's 15 years for those of you playing at home. For the 4 grams. So, we're pretty serious about this. All right? So that's the ire of Congress who wrote all this. Okay, so while this was occurring, simultaneously with this, Congress was also considering whether or not maybe this was too punitive. In 1995, the Sentencing Commission issued a report to Congress stating that it thought the 100-to-1 ratio was too much. In particular, it's stressed that the then mandatory guidelines helped make the ratio excessive because the guidelines, which were not in effect when Congress created the ratio, addressed some concerns Congress thought about crack. So at the time, the guidelines didn't exist. Then the guidelines were mandatory when this guy was punished, and now they're not mandatory again. So the law has changed several times in the relevant time period. Addressing these concerns both through ratio and guidelines, right? Because that's like a double. So the commission says, yeah, that's double punishment. It's not that you can't do this. It's just not necessarily good to do this. You're punishing them through a modifier on the weight, and then punishing them further through the guidelines. So you're kind of getting a twofer there, and maybe that's not so great. Separately, although the commission thought it was reasonable to conclude that crack cocaine possesses greater harms, it determined the ratio overstated the difference. Finally, the commission notes that persons convicted of crack were disproportionately black, so the ratio too high created a perception of unfairness, even though there's no reason to believe racial bias or animus undergird the initiation of the federal sentencing law. So, hey, the Federal Sentencing Commission, at least, came to the conclusion that disparity in outcome doesn't necessarily imply animus or racism or discrimination on the front end, right? Maybe the reason it's coming out differently is because different people are engaging in different behaviors, and these people are engaging in them in disproportionate ways. But that's just a results-oriented approach. So we don't think that you had animus in this, but we would like to know that it did come out this way. So in your whatever you're trying to encourage, this is what actually occurred in the real world, Congress. So 2 years after petitioner was sentenced, these attempts to change the ratio came to fruition. So the ratio was still in place at the time he was sentenced. In the Fair Sentencing Act of 2010, Congress reaffirmed its view that the triggering thresholds should be lowered. It reduced the ratio from 100 to 1 to 18 to 1. It did so by increasing the crack quantity thresholds from 5 grams to 28 and 50 grams to 280. These changes did not apply to those who had been sentenced before 2010. So the changes Congress proposed were not retroactive. The Sentencing Commission then altered the drug quantity table to calculate guideline ranges. The Commission decreased the recommended sentence for crack offenders to track the statutory changes. It made the changes retroactive, giving previous offenders an opportunity for resentencing. Courts were still constrained, however, by the statutory minimums in place before 2010. Many offenders thus remained sentenced to terms above what guidelines recommended. Congress addressed this issue in 2018 by establishing the First Step Act. This law made, or attempted to make, the 2010 statutory changes retroactive and gave courts authority to reduce sentences of certain crack cocaine offenses. Huzzah! Huzzah, right? So Congress has changed its mind. Congress has changed its mind and said, hey, we don't think crack cocaine is as bad as we used to think it is. We'd like to change the ratio. And initially, so Congress actually changed its mind twice. Congress first said crack cocaine was really, really bad, really, really bad. Second thing Congress said is, okay, crack isn't as bad as we thought it was, but we're not going to change it retroactively. And the third thing that Congress said is, okay, we think it's really bad and we're going to change it retroactively. Or at least that's what they tried to say. Now, Congress may do this because Congress may make something less illegal or less punitive retroactively. Congress may do this, but can Congress do it? Petitioner initially sought resentencing under these new retroactive guidelines, but because his sentence was based on recidivism, not drug quantity, his attempt was unsuccessful. Yeah, because his sentence was based on previous bad stuff, right? He was in a category in the guidelines. The guidelines say, how bad is this offense? And how bad of a criminal are you in general, right? How bad is this? How bad you are in general. We think that if you've done more bad things in the past, you should be sentenced more for the same thing within the law, right? So it's like we're not changing the range, but we're like, you've done other bad things, so you've proven that you're recidivist, so we're going to punish you more. All right? So the reason this guy punished so much was not because of the drugs, but because of his prior history, so it wouldn't apply to him. The district court denied the motion. The 11th Circuit affirmed, holding that offenders are eligible for a sentence reduction only if they're convicted of an offense that, and this is the critical part, triggered a mandatory minimum. Because remember, he wasn't inside. There were three different thresholds. There was, do you have at least 5 grams? Do you have at least 50 grams other? Right? And he was another, so it wasn't a mandatory minimum for him, because he only had 4 grams. He must have thought he was so lucky when he was being sentenced. Hey, there's no mandatory minimum for me because I only had 4 grams, not 5, man. Woof. So lucky. So lucky. I only had 4 grams, not 5, so no mandatory minimum for me. Now, as it turns out, I'm going to still sentence you to like 15 years in jail. But hey, at least that's not a mandatory minimum. But wait a second. When Congress wrote the First Step Act, they only changed the law for mandatory minimums. Uh-oh. So, now I can't take advantage of that because I didn't have... Wait, no, I had 5 grams the whole time, really. An offender is eligible for sentence reduction under the law only if he received a sentence for a covered offense. The Act defines covered offense as a violation of a federal criminal statute, the statutory penalties for which were modified by certain provisions in the Fair Sentencing Act. Yeah. Here, statutory penalties refers to an entire integrated phrase of the violation of federal criminal law. We thus ask whether the Fair Sentencing Act modified statutory penalties for this particular offense. It did not. Oops. The elements of the offense are presented by 2 subsections. Subsection A makes it unlawful to knowingly or intentionally possess with intent to distribute a controlled substance. Section B lists additional facts that, if proved, trigger penalties. Before 2010, A and B together defined 3 crack-related offenses that are relevant here. 5 grams, 50 grams, other. The elements of the first offense were knowing or intentional possession with intent to distribute crack of at least 50 grams. This subparagraph was punishable by 10 years to life, in addition to other stuff. The second offense was knowing possession with at least 5 grams. This subparagraph was punishable by 5 to 40 years. And then other. Knowing or intentional possession of some other amounts of the drug. Right? 3 paragraphs. 50 grams or more, 5 grams or more, other. Petitioner was convicted of the third offense. Before 2010, the statutory penalties for that offense were 0 to 20 years, up to $1 million fine or both, and a period of supervised release. So you could have gotten literally no time for this. As it turns out, you're going to get 15 years because of other stuff, but hey, the statute allows for no time. Now, here's the critical part. Here's the kicker. After the 2010 amendment, these penalties remain exactly the same. Yeah, because Congress, remember what it did? It changed the rule. It changed the numbers for the weights, right? But it didn't change the other numbers. So before it was, do you have at least 5 grams? Do you have at least 50 grams? And Congress said, strike out the word 5, write in 28. Strike out the word 50, write in the number 480, right? So then, right, because this is being made retroactive, which Congress may do, that would have the effect of potentially dropping people from one category to the next lower category, right? So if before you had, say, 55 grams, right, you'd be in paragraph A. But wait a second, Congress just changed it. They just struck out the word 50 and they wrote in the words 480. Hey, 55 is less than 480. It's a lot less than 480, as a matter of fact. So, hey, good for you. You went from paragraph A to paragraph B. How great, right? Or maybe you used to be in paragraph B, right? You used to have 25 grams of drug. That's a paragraph B offense. But wait a second, Congress just crossed out the word 5 and wrote in the word 28. Hey, 25 is less than 28. It sure is. 25 is less than 28. So, great. You're moving from category B to category C. But you were always in category C because you had less than 4. And Congress, they didn't change you. Oops, they didn't change you. They just said, oh, you effectively can drop to a lower paragraph. Right? You could effectively drop to a lower paragraph. But you can't drop below paragraph C because we didn't amend paragraph C and we didn't write a new paragraph D. So when we made that change retroactive that said, hey, instead of less than 5, how about less than 28? You know what 4 is? Do you know what 4 is? 4 is less than both 5 and 28. So it doesn't impact him because Congress forgot about Category 3. Oops. Now, the people who wrote the bill, they wrote an amici. And they said, hey, this wasn't our intent. We just missed that one. Well, unanimous opinion from the U.S. Supreme Court. Learn how to law better. Learn how to law better. That's not what you wrote. This guy was in paragraph C before. He's still in paragraph C. So sure, it's retroactive. It just does him absolutely no good. Because 4 continues to be less than 28. And less than 5. So, all those things. So, no, not so much. Petitioner's offense is starkly different from these offenses that trigger the mandatory minimums. The Fair Sentencing Act modifies the statutory penalties for those. It did so by increasing 50 to 280. I'm not sure what number I said before, but it's 50 to 280. I think I said 480. I was being overly ambitious, but it doesn't really matter. So strike out the word 50, write in the word 280. Great. Strike out the word 5, write in the word 28. Great. Right? It did that. But because A, increase the quantity under subparagraph A to 280 grams, a person charged with those original offense is now subject to a more lenient range. Yes, they are. So if you have less than 280 grams, then you're great, because now you have the equivalent of less than 50, which is good for you. Someone in paragraph B also similarly. So, hey, for those who had at least 5 grams, which is not you because you had 4, that's got to be the biggest kick in the teeth ever, man. That lawyer 20 years ago was probably thinking pretty hot shit of themselves. And I can't blame them. Right, man? I somehow managed, it's like getting a ticket written for under the limit, right? So it's like, okay, there's a speed limit of 65. And I was going 80, but I convinced the officer to write it for 70, right? I feel so good for myself. And then something changes later. It's like, wait a second, I actually would have been better off if the ticket had said 80 the whole time. Can't see that one coming, right? Oh, well. Originally punishable by 5 to 40 years, the offense defined by those evidence is now punished by the 0 to 20. But no statutory penalty change for the Category C offenders who remain Category C. This is hardly surprising because the Fair Sentencing Act addressed the cocaine sentencing disparity, and subparagraph C had never differentiated between the offenses. To avoid this straightforward result, $5 from Nuvi. Everyone should like and subscribe for poorly written attempt at law. I know, right? And we get to make fun of the United States Congress, which is always a lot of fun. To avoid this straightforward result, petitioner and the United States offer a sleight of hand. So the United States Solicitor's Office didn't want this result either, but, So, yeah. Petitioner says the phrase statutory penalties in fact meant penalty statute. The United States similarly asserts that petitioner is eligible for a sentencing reduction if the Fair Sentencing Act changes the penalty scheme. But we will not convert nouns to adjectives and adjectives to noun. So they wrote statutory penalties, which what they meant penalty statute, which we'd have to change parts of speech and change what words mean. We are not going to change adjectives into nouns or nouns into adjectives. We're not going to change pronouns. As stated above, statutory penalties references the entire phrase, a violation of a federal criminal statute. It thus directs our focus to statutory penalties for petitioner's offenses, not the statute or statutory scheme. If penalty statute or penalty scheme were proper focus, neither was modified for paragraph C. To modify means to change moderately. The Sentencing Act changed nothing in paragraph C. Paragraph C reads exactly the same as it ever did. Hard to modify something when it doesn't change. The United States notes prosecutors before 2010 could charge offenders under subparagraph B if the offense involved between 5 and 28. Now, prosecutors can charge the offenses only under paragraph C. But even before 2010 paragraph, prosecutors could charge those offenses under C because quantity had never been an element under the subparagraph. Yeah, so so the prosecutor could charge you under B or A if you have the right amounts or not. Because there's also, it's a violation to have at least 50 grams of this. It's a violation to have at least 5 grams. It's a violation to have any amount, right? So if you have 50 grams, you also have 5 grams and you also have any amount, right? So, hey, prosecutor's choice, right? You can charge them under any of them because any of the definitions apply, right? So, yeah, you could have charged them under C. That was an option, yeah. It also defies common parlance to say altering a different provision modifies this provision. If Congress abolished the crime of possession with intent to distribute, prosecutors would then have to bring charges under a lesser included of simple possession. But nobody would say abolishing the first offense changes the second. Yeah. So if Congress, for some reason, decides in its infinite wisdom to abolish the crime of possession with intent to distribute, simple possession is a lesser included offense. You can't have possession with intent to distribute unless you have possession. So if Congress, in its infinite wisdom, decides to abolish the crime of possession with intent to distribute, what does that do for the crime of possession? Nothing. It would work the other way around, right? If Congress abolished the crime of possession, well, you can't have possession with intent to distribute now, can you? But can you have possession without intent to distribute? Yes, it's just called possession. So, yeah, in light of the clear text, we hold the statute is modified. Yeah, this guy can't get a resentencing, so no, not for him. Yeah. And then Sotomayor offers an opinion. Say that she agrees with the opinion and joins part 2 and concurs in judgment. So she includes a footnote. She writes a footnote to be a little bit salty at the majority opinion. So she wants to criticize the court's reciting of history, and then goes blah, 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 and says, here's how I recite history. I write separately to clarify the consequences of today's decision. While the Fair Sentencing Act of 2010 and the First Step Act brought us a long way, some people have been left behind. Among them are people like the petitioner, who is convicted under the law for possession with intent to distribute a small amount of crack cocaine and was sentenced as a career offender. He was convicted of possession with intent to distribute 4 grams, but whatever. If Terry had been convicted under A or B, then he'd be eligible for resentencing. He sure would. Similarly, despite being convicted under C, if Terry's sentencing range had been calculated like a non-career offender, he'd been eligible for a sentencing reduction when the United States Sentencing Commission retroactively reduced the amount. But because he was convicted under some paragraph C and sentenced as a career offender, he's never had a chance to act for a sentence that reflects today's understanding. Absent from action from the political branches, he never will. So, Congress, if you want to give this another shot, if you want to pass the Terry Crack Restitution Act and give us another go, give it another shot. But don't expect us, the court, to fix your screw-ups. You guys wrote the law. You had an entire deliberation process. You've got 535 members, many of them with law degrees. You've got support staff. You've got professional support staff on top of personal support staff. You've got the Congressional Research Service. You've got people whose entire job it is to help Congress law. And then you got all the outside bodies to help Congress law. You have a whole deliberation process to help you law. Don't expect us to fix it. Just write better laws. Think it through. Section 841 provides 3 tiers of penalties. As a baseline, C provides this, A and B provides this other stuff. As enacted in 86, 841 created this 100-to-1 ratio. Then there's some amounts of drugs. The sentencing guidelines were changed, and blah, 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 blah. Crack cocaine sentences were about 50% longer than powdered cocaine as a practical reality. This had some impact on black populations in particular. There's no meaningful policy justification for this. Debatable. But Congress agrees with you right now, so okay. Blah, blah, blah. The Sentencing Commission produced detailed reports to ask Congress to reconsider. Congress reconsidered. The amendments had two principal shortcomings in the initial law. First, the changes were not retroactive. Second, not all offenders can move for reductions. And blah, blah, blah. Terry possessed just 3.9 grams of crack. His guideline range would normally be about 3 to 4 years, but he was sentenced as a career offender because of 2 prior convictions, and that caused him 15 to 20 years. He received the sentence because of this. Career offenders were not, however, free from the harsh effects, blah, 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 blah. Fix your law, Congress. All right, yeah, so fix your law, Congress, and yeah, do better. So there you go. There you go. Just fix your law and do it better. So I will answer some questions about this unanimous opinion. With the Sotomayor concurrence, who wants to go into a little bit detail about history and wants to rewrite the history a little bit and whatever, and say also how screwed up it is. Isn't there something where discretions have, No Corson said, isn't there something where a judge has some discretion based on what the intent of the law was, and not if the law of the words are unclear? It depends what you mean by discretion. If you mean with respect to the sentencing guidelines, no, not at the time period. At the time period that Terry was sentenced, the guidelines were mandatory. They'd be struck down as mandatory later by the U.S. Supreme Court, but that hadn't happened yet. And the Supreme Court didn't make that change retroactive. So at the time, the judge didn't have discretion in terms of sentencing, right? So the judge's decision was, well, do you have the requisite amount? And apparently you did. You get 3.9 grams seems to be the right amount, right? So at that point, it's a mathematical formula. It was a 216 box grid, right? So you just look up how bad is this offense, which is defined, and then you look up how bad is this guy from previous offenses, which is defined, and it puts you in a box, and you're in the box, and you can't move from the box. So at this period in time, judges did not have discretion. This was very controversial for a lot of people, including me. Eventually, the U.S. Supreme Court would come along and say, okay, let's make it just optional again, which it is now. But yeah, there wasn't discretion at the time. So, and there's nothing ambiguous about the law, so there's no discretion here. So, no. Unfortunately, no. And also, the words of the law beat intent, at least if you're me, right? If you're like an originalist, textualist, right? You're all about what does the letter of the law say? And a little bit less about intent or purpose or meaning. You're just about what does the words mean and what did they mean at the time, right? So you can get into interesting debates on that. I had a slightly interesting conversation with Nick Rikita on this point as we were driving back to the airport when I was coming home, right? Because we were discussing what we thought the word arms meant within the meaning of the Second Amendment, and we had a disagreement, right? So we could have a disagreement about, okay, what exactly were they trying to say? What did arms really mean at the time? What were they talking about, right? So we had a bit of a disagreement, and it was fine. We both like each other. But, I don't see a lot of ambiguity here. Like less than 5 grams, not a lot of ambiguity. I got it. Yeah. Is the only way to fix it to make distribution legal? No. So possession is illegal, but sales conducted and you have sold it, you're all free and clear. No. You don't have to fix it by making distribution legal. No, you don't have to do that. You just have to figure out what you want to do in terms of, you could. That's a possibility, but it's not what you have to do. You could do other things. You could rewrite paragraph C, or you could make the non-mandatory nature of the sentencing guidelines retroactive too by statute. That'd be fine. Or, there's a lot of things you could do here as Congress. Or you could pass a private bill just for him. The just for Terry law, a private bill just to fix his problem. You can do a lot of things. Yeah. Yeah. You can change the sentencing guidelines for paragraph C. Yeah, you could do a lot of things. Get the president to pardon him. There's an option. Or commute, right? Hey, there's an option, right? The president could commute those sentences. Yeah, he doesn't even have to pardon. He can just commute them, which is just shortening them. So the president could just commute them all, reduce them all to some lesser time. So he doesn't have to pardon him. So Biden could commute a sentence. He could say, okay, well, so you're still guilty. You still have the conviction. You just change the time by executive order, which you can do. You can lessen it. Commutation, it's fine. $2 from Randy Man, who says I'm broke. Well, I appreciate your $2 in any case. It's very, very kind of you. So, yeah. So that's a pretty easy statutory read from the Supreme Court. Not a lot of ambiguity on that one. Doesn't have to be a federal case for the president to pardon, yes, but this was a federal case. He was sentenced under federal guidelines. He was sentenced federally. So, yes, but that's not a factor here. And it wouldn't be we wouldn't be talking about this all if it wasn't a federal conviction. Yeah, I mean, Congress can only change federal law, right? So he was convicted of a federal law. He wasn't convicted of state law. He was tried and charged federally. Whatever might be true state-wise. So, yeah, he was convicted of federal offenses. So, yeah, no problem there. So that'd be good. All right, I'm going to sign off for now. If you're enjoying the stream, please remember to give it a like. Hit the notification bell if you haven't already. If you're not subscribed already, hit the subscribe button. Hit the join button for 99 cents. You too can become an uncivilian and help support the channel. I hope you liked this stream. I hope you learned a lot too. And if you ever run for Congress, remember to think through everything a little bit better. I've been Uncivil Law. Hope all is well. Cheers and goodbye.